This question asks, what if my child was put on the deed at the time of purchase? And specifically, they were asking about Medicaid asset protection in the 5-year look-back period. So if your child was put on the deed at the time of purchase, if that purchase was more than 5 years ago, no problem. If it's within the last 5 years, then they have the right to dig into the transaction and find out, did your child put up half of the down payment? Are they making half of the monthly payments, to verify that adding them does not constitute some sort of a gift, which is what they're always looking for. Now, the next piece of this equation is it your homestead? If we're here in Florida and it's your homestead and your child was put on the property more than 5 years ago, they don't really care. If you've done it within 5 years, it could be a gift situation, but generally in Florida, for most folks, your home is not a countable asset for the Medicaid asset analysis. In other states, that could be very different. But there is another component here, and that is taxation. So after you die, if your child decides to sell the property and they were put on the deed either at the time of purchase or by you as a joint owner at any time up until the day you die, then for tax purposes, when they sell the property, they will be treated with what's called a transferred basis, which means they will very likely be subject to capital gains income tax treatment on the full spread between what you paid for the property when you bought it and what they sold it for after you died. And depending on how long you've owned the property and the market increases in equity, that could be a really big number in taxes. And then, so to pre-answer the follow-up question is, well, what if I added my child 3 days before I died, but I bought the property 30 years ago, do they still get the basis on the day I gifted it to them? Nope. Unfortunately, goes all the way back to the date of purchase. So again, doesn't work. I highly recommend for the tax treatment something like a ladybird deed here in Florida, or a transfer on death deed in other jurisdictions if your jurisdiction has one, as well as ultimately a trust, irrevocable or irrevocable, I think is the best option. So putting your child on your property may or may not cause a Medicaid problem, but it likely will cause a federal income tax problem that can be avoided through proper planning. Have a great day.